Technology to Combat Drunken Driving, Ignition Interlocks. My name is Ann Teagan, and I am a program principal here at NCSL. I will be your moderator today, and we are definitely welcoming questions, and you may submit a question at any time during the hour in the question box on your menu screen. After both presenters are finished, I will then read aloud the questions that have been submitted. We are very lucky to have two wonderful presenters today. Our first presenter is Maureen Perkins. Maureen is a program analyst in the Impaired Driving Division of the National Highway Traffic Safety Administration. She received her bachelor's degree from Loyola University, New Orleans, and her master's degree in public health from St. Louis University. She is responsible for Ignition Interlock Program development in the Impaired Driving Division. She develops the model guidelines for State Ignition Interlock Programs that we will be talking about today and manages Ignition Interlock projects with the Association of Ignition Interlock Program Administrators, Governor's Highway Safety Administration, and the Traffic Injury Research Foundation. Our second speaker is Tom Liberatore. Tom is the Director of the Office of Driver Programs for the Maryland Motor Vehicle Administration. He received his bachelor's degree from Frostburg State University and his master's degree in applied psychology from the University of Baltimore. He oversaw the development and initial implementation of Maryland's first automated ignition interlock monitoring system for the MVA. He coordinated key system changes for the MVA in the areas of Real ID and CDLIS modernization and helped organize the first national assessment of a statewide driver education program. He also serves as the president of the board of directors for the Association of Ignition Interlock Program Administrators, a professional association for managers of state ignition interlock programs, and that is the hat he is wearing today. Before our speakers start with their presentations, I would like to give a brief look at legislative trends related to ignition interlocks. In the early 2000s, only about 40 states had laws that specified which offenders needed to install ignition interlocks for certain offenses. By 2011, all 50 states had passed some sort of ignition interlock law. In 2005, New Mexico became the first state to require ignition interlock devices for all convicted drunk drivers, including first-time offenders. Now 15 states require interlocks for all offenses. Colorado and Illinois provide strong incentives for first offender installation, and California currently has a 4-county pilot program, including Los Angeles, that requires all convicted drunk drivers to install ignition interlocks. In 2014 already, New Hampshire, New Jersey, and Wisconsin have introduced mandatory installation for first offense. State laws are changing to make offenders eligible to drive legally with an ignition interlock much sooner than they were in the past. The enactment of MAP 21 in 2012 gave states, without losing federal highway funds, the flexibility to not only pass laws that allow immediate interlock installation without a 45-day license suspension, but also to decide to which locations the repeat offenders can drive. At least 5 states in 2013 shortened their driver's license suspension periods if offenders installed an ignition interlock device. For example, Colorado amended its license suspension time from 1 year to 1 month if the offender applies for an ignition interlock restricted license. Maine and Mississippi now allow a first offender's license to be reinstated after a 30-day suspension if an ignition interlock is installed. And Arkansas now allows for an offender to apply for an interlock restricted license immediately with no license suspension time. Alabama and Delaware have introduced legislation that would allow offenders to be eligible for an ignition interlock restricted license sooner in 2014. Also, in 2014, there is a Georgia bill pending that would repeal restrictions on where an offender can go under the restricted interlock license. So far in 2014, states have considered about 350 bills related to impaired driving, and many of them concern ignition interlock devices. Interlock legislation can address the length of time the offender must have a device installed, to penalties for tampering, to the agency responsible for administering the program. The National Highway Traffic Safety Administration released model guidelines for state ignition interlock programs in November of 2013. As I said, Maureen Perkins played a pivotal role in developing the guidelines, and she is here to speak with you now. Welcome, Maureen.
Thank you, Anne. Good afternoon, everyone. Like Anne mentioned, I'm going to be discussing ignition interlocks in general and NHTSA's model guideline for state ignition interlock programs. So if you look at the next slide, for those of you briefly who may not be aware, what exactly is an ignition interlock? The interlock system basically ensures that a vehicle cannot be started or driven by a person who has been drinking. Ignition interlocks have been in use in the U.S. for over 20 years. They're a device installed in a driving while impaired, or DWI, offender's vehicle that requires a breath sample from the driver before the car will start. If the breath alcohol content of the driver is above the set point, which is usually 0.02, the vehicle will not start. If you go to the next slide, some of the benefits of ignition interlocks for the DWI offenders are that research has shown that while ignition interlocks are installed, they reduce recidivism among both first and repeat offenders. They allow the driver to drive legally with license. And this also benefits families because it allows the DWI offender to continue working, continue fulfilling their responsibilities, and drive legally. Also, surveys have shown that family members were positive about the interlock and its impact on their loved ones. It can change their drinking behavior, and it provides an assurance that the offender isn't drinking and getting behind the wheel. Interlocks are also a predictor of future DWI behavior. Research has shown that the higher the rate of failed tests, the more likely offenders were to recidivate once the interlock was removed. So by looking at the number of failed tests, you can target which DWI offenders are at higher risk for recidivating. Also, there's a cost savings. Ignition interlocks cost less than incarceration and other types of monitoring that's available. If you go to the next slide, who pays for the cost of ignition interlocks? Most fees are borne by the offender. On average, the installation fee is about $70 to $90, and monthly fees are about $70, which costs roughly $3 to $4 a day, which is the cost of a typical drink. Some states also have set up indigency funds that will provide funding for those DWI offenders who may find these fees to be unaffordable. And there's several different eligibility criteria that you can use. Some states require a DWI offender to provide proof of participation in a government assistance program, while other states use multiple criteria, develop their own form, which looks at things like an offender's income, their assets, their monthly expenses, their living arrangements, and other kinds of information to get a more accurate picture of the ability of the offender to afford the interlock. If you'll go to the next slide. Sort of a brief detail on the number of ignition interlocks in use. As Anne was saying, all states allow or require the use of ignition interlocks. There's an estimated 1.4 million DWI arrests each year and an estimated 305,000 interlocks installed. So there's clearly some room for improvement. If you go to the next slide. There are 3 different types of ignition interlock programs at the state level, and I'll just be going over these briefly. I know Tom, our next speaker, is going to be providing some more examples and details, but administrative programs are usually with the licensing agency, and it's requiring an interlock as a condition of your license reinstatement. A judicial program is through the courts and will mandate an interlock either pre-trial or post-conviction, and a hybrid program will have features of both. So you'll go to the next slide. So the model guideline for state ignition interlock programs was developed to ensure consistent and effective interlock programs nationwide and provide states with practical strategies based on successful programs in key program areas. And I'll be going through each of these in detail, but they are legislation, education, program administration, devices, vendors, data, and licensing. So if you go to the next slide, under legislation, we feel strongly that you should require interlocks of all offenders, including first offenders. Also, that you should designate one agency with the authority for the program. and make it easy for people to enroll in the program by eliminating barriers. And some of these barriers or eligibility requirements could be something like paying outstanding fees or fines or completing a rehabilitation program prior to having the Ignition Interlock installed. Also, minimize the ability for offenders to opt out of the program. You also want to legislatively establish the minimum length of time for offenders to be on the interlock. If you'll go to the next slide. Education. So when we're talking about education, there's a couple things we're talking about here. There are numerous agencies involved in an interlock program at the state level. There's courts, licensing, probation and parole, treatment, law enforcement, and all of these different players should be educated about how the device works, what the state laws are regarding ignition interlocks, and what the license restrictions are, what the benefits are, who's collecting the data, what are the violations, and what are the consequences. And also, DWI offenders need to be trained in how to use the device, what the program rules are, and what are the consequences for violations. If you'll go to the next slide. For program administration, again, we feel what agency should be in charge or have authority over the Ignition Interlock program. You want to ensure that all offenders in the state have access to Ignition Interlock service providers. And really what we're talking about here is some of the rural areas. And there's several different ways that states have addressed this. Some of them have sort of split up the state and designated vendors for certain areas. Others have done a 50-mile radius where a vendor is required to have at least one service center within 50 miles of each resident. So you want to make sure that no matter where the DWI offender lives, they're able to fulfill their requirement and have an interlock installed. You want to establish eligibility for the indigency funds, which I spoke about a few slides ago. And you want to have a plan and implementing strategies to become self-sustaining. So costs wherever possible should be paid for by fees from the offenders or from the Ignition Interlock vendors, and have a plan to be self-sustaining. You want to establish rules on offender monitoring and program evaluation. So what are going to be the procedures to ensure that an interlock gets installed, that the car is actually being driven, what are the requirements for reporting to a service center for maintenance, how often should the data from the device be downloaded. All of those types of rules should be included. You also want to consider having an increase in sanctions with multiple violations. And some states also have performance-based requirements for removal, where you have to be free from violations for a certain period of time before you can exit the Ignition Interlock program. If you'll go to the next slide. So the Ignition Interlock devices themselves, you should have a process in place in your state to whether or not which interlocks are going to be approved for use. And most states have requirements where you need to meet or exceed the NHTSA model specification. And the model specifications were developed to determine if the Ignition Interlock device meets certain accuracy and precision standards. You'll need to have a process in place to determine what the testing procedures are to make sure that they meet those specifications. And what happens if a vendor proposes a modification to these devices? How will you request them to notify you of this modification, and how will you process that change? Also, these devices are very sophisticated and constantly changing, so you want to know what happens when new technology is being proposed in your state. How do you determine how that feature will be allowed? And these could be things like GPS or cameras or facial recognition software. If you'll go to the next slide. For the vendors, you want to create a vendor oversight and management plan. You want to know, also briefly just to clarify, sometimes you'll hear different terms. Manufacturers are those that actually produce the devices. Ignition Interlock vendors are those that distribute them. And service centers or providers are those that actually install the device. And the service centers can be contracted out by vendors to complete the installation. So some of the things you want to have in a vendor oversight plan are to define the vendor violations. So what are those violations going to be? It could be things like, you were supposed to provide coverage to certain areas of the state and they're not doing that, or they need to require training for their installers and that's not taking place. So how are you going to monitor that? It could be conducting on-site inspections of the service centers or other ways of monitoring. some of the penalties, there should be just as there's a certification process in your state for vendors, there should be a decertification process. If they are having multiple penalties, how do you have somebody become decertified for doing business in your state? There are also the violation definitions, and this is speaking more about if you're having multiple vendors in your state, how does everybody use the same definition for what determines a violation? For failing to install, for failing at breath test, for locking out, making sure that all the vendors in your state are using the same definitions. You also want to establish standards for licensing and the operating of service providers. You'll go to the next slide. So the interlock actually captures a lot of data in the data log. It's going to capture the breath test, the BAC level, or the breath alcohol content, the failure to submit a test, when the vehicle is turned on and off, any tampering events. So you need to figure out what's going to happen with this data. Who in the state is going to have ownership and security of the data? How are you going to be working in partnership with the vendors? And you'll need to determine the roles and responsibilities of the agencies involved. Where is the data going to be housed? How is the data submitted? Who can access it? And who's responsible for monitoring that data? And you want to link all those data systems together. So all those players that we've talked about before, the courts, the probation and parole treatment, what pieces of information do they need, and how do you link their data systems? You'll go to the next slide. So with licensing, you want to make it really easy for someone to know that this person is supposed to be on an ignition interlock and require that restriction be marked on their license. You'll also need to establish procedures to notify offenders of the requirement and status in the program. If they've had a violation, are they going to be extended time on the program? How do you know that they're supposed to have one installed? You'll need to licensing has to coordinate with courts, offenders, and service providers. Another issue that comes up often, especially with states that have multiple borders, is establishing reciprocity with other states. What happens if you have an offender in one state, but they've gotten a DUI in another? Each state's program is different. They may have different vendors and different requirements, and how do you handle that? And if you go to the next slide. So some of the NHTSA resources we have, in addition to the guideline that I just sort of briefly went over, are the Ignition Interlock Toolkit, and this is a summary of the research and some other basic information about ignition interlocks. There's the Ignition Interlock Curriculum, which was developed in cooperation with the Traffic Injury Research Foundation, and that has a lot of information about the devices themselves and is for practitioners. And then also there are model specifications for ignition interlocks. If you go to the next slide. So that's my portion of the presentation, and next we'll have Tom Liberatore is going to speak about ignition interlocks and the Association of Ignition Interlock Program Administrators. He'll be providing some more details specifically from the state's perspective.
Hello, thank you, Maureen. As Maureen said, I am Tom Liberatore. I'm with the Association of Ignition Interlock Program Administrators. And as you can see on the next slide, we'll be talking about a few things today in relation to ignition interlocks, and they sort of go hand in hand with what Maureen was talking about and the program guidelines that have been placed out by NHTSA. So there are really going to be three basic areas we're going to be covering today, which are key issues facing interlock programs. That's sort of mingled throughout the presentation that I'm going to be giving. Emerging device characteristics, and resources and information, which will be at the end of the presentation, where I'll provide some current resources that we as the association provide to members, or really to anyone that comes across our website, and also links to some of the information that NHTSA has put out on some of the other research agencies that are also conducting research into ignition interlocks. So if we go to the next slide, we see a little bit about what APA is. We were formed in 2011. We are a nonprofit professional association. Our membership is composed primarily of program managers of state-based ignition interlock programs. So it's mostly individuals like myself. Personally, I'm an employee of the state of Maryland, the Motor Vehicle Administration. Most of our membership is composed of individuals similar to myself, depending upon what facet of the interlock program that they manage. We have about 21 member jurisdictions in the U.S. and Canada. We were going to put international association, but there's just too many I's in the name of our association, so we just stuck with what we have there. We have basically 5 main purposes we're surrounding the formation of our organization: to develop and improve interlock program administration, identify resource issues associated with interlock devices, develop and promote training programs, assist individuals and organizations in developing best practices for the programs, and also to organize conferences, reports, that kind of thing. The next slide, please. We show basically what Maureen just covered. Sort of the reason why the association was formed, and really the reason for the webinar today, is there are all 50 states have some form of Ignition Interlock program, and there are probably 50 different types of Ignition Interlock programs, as each individual state and each individual legislative body or executive agency has put their own state flavor or requirements into their interlock program. On the next slide, we sort of go into some of the key issues that are facing Ignition Interlock program administrators, state legislative bodies, and executive agencies across the country. Basically, just some common underlying facts. There's been a lot of research that has been done where interlocks have proven to be reliable and effective. There's multiple research studies demonstrating that they reduce recidivism while the device is installed. That's a very important parenthetical statement, while the device is installed. And they are commonly cited as a factor in contributing to decreased impaired driving fatalities and crashes, although some recent data is indicating the fatalities and crashes sort of bounce around a little bit, but generally the trend, over the last 5 to 10 years has been for decreasing in that area. And while you can't isolate interlocks as a specific factor, there are lots of things that went into it. They're certainly highlighted as a contributing good thing that led to that trend. Some of the common things as interlock program managers that we find are what structure of the program are we going to be talking about? What is our plan, or how do we make sure the vendors, and this, when I say vendors, Maureen made a very good point earlier. There is a very clear distinction between manufacturer and vendor. While from the state's perspective, they work hand in hand. The manufacturer makes the devices. The vendor is sort of their franchisee in that state. We sort of lump them together when we talk about vendor oversight. Device functionality. How is the device to function? How do you make sure it's functioning correctly? Data management, as Maureen pointed out also, these devices collect an enormous amount of data about the individuals that's using them. What does the state do with it? What do we want to do with it? And also a question that comes up a lot is the affordability question regarding interlock device installation. So in the next slide, we see we sort of created this, I don't want to say spoken wheel, but for lack of a better term, spoken wheel, that are really the 5 sort of key components as an association that we've identified that go into an effective, or at least need to be considered when you're talking about managing an effective interlock program. Oversight, program structure, device functionality, the delivery system, and program management. What we mean by delivery system is sort of more encompassing of how are the devices delivered, how are they installed, what's the specifications that the state has put in place for that. Next slide, please. So when we talk about program structure, which is sort of the first thing that we mentioned a few slides ago, there are really 3 basic models, and also Maureen touched on this as well, that states can have when they talk about Ignition Interlock programs. So there's an administrative program structure, which is license-based, judicial, which is court-based, and hybrid, which, as you probably guessed, is a combination of both administrative and judicial. Some of the other things that we get into regarding program structure is where does the legislature in that state want, or the executive agency or whatever agency is going to be associated with managing the interlock program, where do they want that program defined? There are some benefits to having it in statute and law, and there are some benefits to having most of the program defined in rule and regulation. A lot of the questions that we get asked are, what do you want in terms of a program definition? Do you want something more flexible or more rigid? Obviously, as research comes out, a program that is more clearly defined in administrative rule, where the actual requirements of the program, how you want individuals to be enrolled, or the definitions for removal or violation. If it's an administrative rule, depending on the state, can sometimes be a little easier to modify that based on research trends, upcoming data, as opposed to legislative, which obviously requires passage of an enactment of new statute. As already said, and I think this is pretty self-explanatory, programs can vary widely across the country, as you have each individual jurisdiction's requirements for how they want their program to function. So on the next slide, we go into the administrative license model a little bit more. Some examples are Florida, Illinois, and Oklahoma are basically states that, for lack of a better term, for the majority of their installations, have what's called an administrative model. The advantage for it are what we call installation rates, which are basically the number of individuals that are convicted or pulled over for a DUI or an alcohol-impaired violation. Your installation rate is, okay, how many of those individuals that are eligible to be in the program are actually getting the device installed? In administrative programs, that's a little bit more of an advantage, since the licensing agency typically has some administrative control over the issuance of the driver's license and the issuance of a restricted license. They can put that requirement as a condition of relationship. Consistency of use, usually in your administrative agencies, the management of the program, the management of the participant in the program is usually done through one agency, so it's more uniform. And it tends to be a little more cost-effective and streamlined in that you're not dealing with a huge number of agencies. That last bullet, though, really depends on the type of program that you have. The disadvantage to it is the authority. The really only authority that an administrative-based program has is they're going to take action against your driver's license. And unfortunately, research has increasingly shown that individuals that have a suspended or revoked driver's license, a lot of them tend to drive anyway. So that really is somewhat of a disadvantage in regarding to strictly just an administrative model. Also infrastructure. There are resource limitations. Obviously, a driver's license entity or administrative entity has many other functions that they have to perform. So some questions come up, does that agency really have the resources necessary to effectively run the program, which is something that needs to be considered in a type of program assignment or program design. Also staffing challenges, and I'll get into that a little bit more when we talk about data management. On the next slide, we go into the judicial model a little bit more, where we have examples. One pertinent one is New York. The advantage of that is obviously penalties. In that instance, a judge has assigned you as a condition of probation or a condition of conviction or as part of a deferred sentencing to participate in the Ignition Interlock program. That actually carries the force not just of law, but also the force of if you don't abide by the conditions, you can end up in jail, which tends to have a little bit more of an impact on an individual's life than just, say, suspending or revoking someone's driver's license. Resources. Probation-based programs or court-based programs sometimes use probation departments as a monitor, depending upon how your state is set up, if it's a judicial assigned responsibility or an executive branch agency. They have the resources, since there's probably probation officers out there, to fold it into their normal caseloads. That can also be disadvantaged in that these individuals typically have very large caseloads. They also have the ability to impose other requirements, such as treatment, drug testing. There's something called 24/7 monitoring programs now that are being put out that an agency that is a judicial support can impose on an individual. Disadvantage is, unfortunately, there's been typically inconsistent or low use of breath alcohol ignition interlock devices among judges. A key issue that needs to be addressed in this type of program is education of the judiciary on the importance and the benefit of having ignition interlock devices installed. And really, a lot of times at the end of the day, it is the judge's discretion as to whether he or she wants to assign the ignition interlock device as part of a person's sentence or probation. So the next slide, we talk about the combination of the hybrid, which is obviously judicial and administrative. Some examples are New Mexico, which was mentioned earlier, in my state, which is Maryland, where we have a combination of both. So we combine components of both the judicial and the administrative. In our state here in Maryland, we actually have a MOU between my agency and our parole and probation agency for individuals that are assigned either by the court or individuals that are assigned by the licensing authority to participate in the interlock program. So, my screen is on blank here for a minute. So I'll keep going. Cooperation. There's a lot of cooperation between the various agencies, which is very important when you're talking about any type of judicial or hybrid type program. That's why the MOU is important, to delineate responsibilities between the various agencies to make sure that each one knew what they were doing, and the communication data exchange is also worked out. That can also be a disadvantage. If you don't have an effective communication network established, then that can cause problems in terms of working out who has what responsibility, who's taking a judicial action, and who's taking an administrative action. So it's very important in a hybrid model to really make sure that the communication is established. The next slide, we're going to talk about one of the other issues, which is vendor oversight. I think we want one slide ahead. Can we go back one? One more. There we go. Thank you. So vendor oversight, obviously, is something that is very important to an Ignition Interlock program. Without an effective provider network, and like has been mentioned, some states have requirements for providers to have so many within a 50-mile radius, so many per 1,000 participants. Without the provider network, it is very difficult to have an effective interlock program. So relationships between the state monitoring agency or the agency targeted with responsibility for managing the interlock program and vendors is very important. Going on with that, it's very important to have a clear documentation of responsibilities. How are your vendors selected? If they're selected, what's the process they have to go through to be assigned in your state? Does your state limit the number of interlock vendors? There are some states that, for restraint of trade issues, do not, and they can have upwards of 6, 7, 8 interlock vendors in their jurisdiction, and there's really not a sufficient population to support having that many vendors. So these are all things that a state should consider. There are some states that cap or have an RFP process where they say, okay, this is the vendor that this state or the 3 vendors this state is going to use. So depending upon how the selection process in each state is defined, it's very important to make sure vendors are made well aware of what that is and what their expectations are. Another thing that comes in is, where are your vendor requirements defined? Are they defined in law? Are they defined in rule? Are they defined through some type of contractual agreement? There's benefits and advantages to each of this. Obviously, something in statute, if you were, but you needed to change that, you need to go back and enact new statutes to modify that, whereas something in rule or through a contractual agreement may be a little bit easier, especially a contractual agreement with the agency that is responsible for overseeing vendor performance. They can modify contracts and put the conditions in there. Device calibration and performance standards is also a very, very important piece of information to make sure that every state talks about. It is very, very critical that a state define for the vendor, are we using the current NHTSA model specifications? Are we using what standard? If we're using our own standard, what is that going to be? Because this really forms the backbone of your program. If you don't have a reliable, clearly maintained device with a reliable and clearly maintained vendor oversight plan, then if there are ever issues where the results of the device are challenged, you don't have the supporting documentation to really declaratively say, yes, we overlooked this device, we oversee the device, and this is why we think what's coming out is valid. How are they enforced? So how are you going out and making sure that whatever vendor you select for your state is really going by what the requirements are? Do you have inspections? If you have inspections, do you have a form? Are they recorded anywhere? Do you have a vendor oversight plan? Creation of a vendor oversight plan can be very important. It delineates your responsibility as a state oversight agency and also delineates the vendor's responsibility as an operator within that jurisdiction. Next slide, please. Let me talk about device functionality. So vendor oversight and device functionality sort of go hand in hand. The reason you have vendor oversight is to make sure the device is functioning properly. The model specifications that were provided by NHTSA, they were put out last year. Actually, they were put out at our conference. They were publicly announced for the first time last year. Have a lot of important tools for states to utilize. They define the scientific standards that a device should meet according to NHTSA. Jurisdictions obviously maintain ultimate control over the device standards. Some jurisdictions say, yep, we're going to refer to the NHTSA model specifications for 2013. However, we're also going to put these additional requirements on a vendor. So states obviously have the freedom to do that. Emerging technology. One of the reasons why states do that is to put definitions around this emerging technology. The use of GPSs, accelerometers, cameras, which take not just still pictures, now the cameras have to take both digital pictures and also can stream live video, if required, of the individual utilizing the interlock device when a breath sample is provided. Calibration. It's critical for a state to define and enforce, that's why I underline and bolded enforce, calibration requirements. At the end of the day, that is really what determines that the device is providing an accurate reading for both the individuals in the state monitoring the program and also for the individual using the interlock device. Any circumvention requirements, there are some anti-circumvention features built into the device. Breath patterns, learned breath codes, breath temperature, blow hum, sample volume, the cameras, which actually can be used as an anti-tamper seals. So there are a lot of anti-circumvention components within the interlock devices, and it's important for each state when they're looking at approving a vendor, or if they've already got a vendor approved, to really go and ask them if they're unsure, what are the anti-circumvention requirements that is in your device right now, and if there are other things that the state wants to require. Do you want to require shrink-wrap seals around connections to make sure that no one's bypassing the device? Do you want to require a different type of breath sample code in order to make the device function? These are things that's very important for state programs and legislatures to discuss. Next slide, please. Data monitoring and management. There are two standard approaches to device data. You know, program agency controlled or manufacturer vendor controlled. We could probably have an hour-long discussion just on data management and device calibration. The important thing with this is basically to pull out of it is there are two main methods. Do you want the state agency to get the data and control what happens to it, or the state agency to get the report and determine what action to take, or do you want the vendor to coordinate that kind of communication on behalf of the state to the individual using the interlock? There are advantages and disadvantages to both. States utilize various combinations. You know, in Maryland where we are, we control the agency, the MVA controls the data, and we actually get the information fed to us. We use what's called in the field an automated data management system. Some states have it. Illinois has it. I believe South Carolina is on the verge, if they don't have one already, of utilizing an automated data system. There's costs associated with that. There's costs associated with having manual intervention on behalf of the state. And these are all things that need to be looked into thoroughly on a jurisdiction when they're considering either moving the interlock program forward or if they want to streamline the way the interlock program is managed currently. Another thing next is affordability. We get a lot of questions about affordability as an association. There are about 20 states, give or take, you know, somewhere around 2 dozen right now, maybe more, maybe less, depending upon how things change, that have some type of affordability. On average, affordability program. On average, installation costs run between $70 to $150. Monitoring can be $60 to $80 per trip. Again, how much a person pays depends upon how frequently the state wants the device monitored, how frequently the state wants the device calibrated, how often they want the information reported to them. Some states do cap fees. They have it in their contract with their RFP or whatever process they use to select a vendor to cap the fees at a specific amount as sort of a price fluctuation control. Program and licensing fees. There are a number of states that charge additional program fees. If you add it all up, you have the fee for the interlock, the fee for the monitoring, any kind of court costs, any kind of administrative licensing fees that are charged. So it can get quite expensive for an individual who is pulled over for an impaired driving offense. There are a lot of active discussions regarding unaffordability right now. You'll hear both terms mentioned, unaffordability and indigency. it's really, they sort of go hand in hand. Obviously the indigency argument is more of a legal rights if you're determined indigent and the provision of counsel versus the administrative requirement of what's a person's overall financial picture. There are many states, Colorado is one that comes to mind, that have unaffordability programs to sort of assist with that. To be honest, they meet with various degrees of success. A lot of states have them, don't have a lot of use in them. So there's still some more research that needs to be done regarding the unaffordability process and how best to interface that with participants. Some other issues on the next slide that we talk over about Ignition Interlock are violations. So what are the consequences for individuals that break a rule of the program? So if your program rules are defined, wherever they're defined, and someone does not follow them, what happens to them? Are they removed from the program? Do they get a count against them where they are extended? Those are all things that really need to be ironed out pretty clearly in terms of what style of program does the state want to have. Over the past several years, interlock programs have sort of moved away from this punitive type assignment to interlocks to more of a behavior modification type model, which is where you have the issues of compliance-based removal coming in, and as opposed to saying you broke the rules, you're out, they're saying, okay, what is the consequence for you breaking the rules? A lot of states are extending time in the interlock. Will require you to have a violation-free period before you're deemed to be okay to be taken off of the interlock program. That is where a lot of research is being focused right now in terms of what is the best structure of a program to have, what type of feedback should we give to the participant, what should that feedback contain, and what is the most useful or effective monitoring methodology to use. Every 30 days, 60 days, 90 days. Many states require more frequent trips, but again, it depends upon how you want to administratively handle the workload that comes along with that. Site inspections, are your staff trained to do site inspections, and do they know what they're looking at when they go out to do the inspections? That's one of the things that we as an association are working on, is putting together a training course for states to use to go, okay, when we go out and inspect these sites, do we know what we're looking at? The next slide, we talk about some practical questions for researchers. Let me have to click it. There you go. Again, what are the ideal set points? Maureen mentioned in her presentation that many states have 0.020, many have a 0.025, some go as high as 0.05. So where do you want that failure set point to be? Which the failure set point is, that's the set point at which the device says, okay, your breath alcohol content is too high to start the vehicle. I'm not going to start right now. What does the violation mean? How should states respond to violations? Are certain violations more important? There's a lot of discussion, now where you see individuals throwing high BAC violations on the device in the morning. Well, what's that indicative of? Most likely, it's indicative of they were drinking the night before. What should a state do with that? Monitoring of participants, is it a benefit or not? I think more research is leading to it is a benefit to monitor participants, and that way individuals know that they are being, I don't want to say being watched, but that someone is monitoring their progress on the device, making sure that they're following the rules of the program, that they aren't continuing or trying to continue to drive impaired or drive at the set point above which the vehicle is meant to run. What kind of feedback do you give to individuals? Do you provide it in writing? That kind of thing. Just real quick, the next couple slides, I just wanted to go over our annual conference that's coming up this year in Baltimore. If the slides are going to be given you in a PDF, the information will be on there. We have a training institute that we talk about on the next slide, and just some additional resources as we go down through the other slides. All this information is accessible through our website, as you see right there at aiipa.org. I encourage you to go there. We have a section that contains research, information about the conference, some additional information we're going to be putting out in terms of standardized terms for interlock program managers. So if there's anything that you see on the website, you are more than welcome to access, so you don't need to be a member to pull the information down. And the last slide, last two slides, is our current board of directors, and the very last one is my contact information if anyone is interested in sending me an email, or you can also reach us through the association website. So thank you very much. And I'm not sure if I'm supposed to hand off to somebody else or not, yes. But if anyone has any...
I think it is a perfect time for questions, and we do have some questions that have come in. I'd like to point out that the contact information for all of the speakers is on the last slide, if you'd like to take a look at that. Our first question really could be for either Maureen or Tom. And that question is, how many manufacturers are there, and do all of these manufacturers and programs capture the same data? Like, are they speaking the same language?
You want me to take a side with that, Maureen, first? I don't know if Maureen...
Well, go ahead.
Okay, thanks. Yeah. You know, there's about 13 to 14 manufacturers across the country. There are certainly your major ones. There are probably 6 or 7, major manufacturers. What I mean by major is they're ones that are more prevalent across the United States. In terms of capturing the same information, they all are, depending upon the state's requirements, typically do capture the same type of information. The devices are proprietary, so they may call it somewhat different things, and the information may be presented somewhat differently to the state. So when we talk about data standardization, term definition, term standardization, that's exactly one of the issues that we're trying to address, is that if you have a state like myself, for example, I have 6 vendors in my state. They used to all communicate to me differently, would fax me in reports differently, and they would say somewhat different things. We went to a standardized data management system where they now all look the same. They all say the same language, and they all report it the same way to us. And that is actually a very good question, because it is one of the challenges that many new program administrators are facing, is sort of combing through what this looks like and weeding it through.
Great, thank you, Tom. We have another question for you, Tom. There's a reference that in your slide on affordability, it states that the monitoring cost is about $60 to $80 per trip, and someone just wanted to ask if that actually meant per month.
Well, that's a good question too. Typically when a state defines their program, there's going to be the installation cost. There's obviously the cost to have the device installed. Coincidentally, there's also cost to have it removed. I didn't put that in the slide, but that's almost the same as the installation cost or the monitoring. The monitoring fee is usually what that is the $60 to $80 a vendor would charge you per month or per monitoring trip. So if your state says every 30 days you have to come in to have your device calibrated, to have it inspected to make sure you haven't tampered with it, and to have the device data downloaded, then every month you would pay that $60 to $80. If it's every 2 months, then every 2 months you would pay that $60 to $80. There are also other fees that a vendor can charge. Many of the devices are set up that if you blow a certain number of what we call high BAC fails, which in the interlock world is anything over the set point of that device, the device locks out and requires you to go back to the vendor to have it unlocked and serviced, which is one, to make sure the device is working correctly, and 2, I don't want to say punishment, but sort of as a reason for the person to come in and say, hey, okay, why are you blowing so many high BAC failures? They also charge for that as well.
So would that require like a tow, since the ignition interlock has locked, would that require a tow truck to take you to the vendor's business?
Yeah, so it can. So vendors can do it a couple different ways. They can go into what's called an early recall, where let's just say it happens in the middle of your monitoring period and you've blown so many failures, they may say you have 1 day to bring the device back into the shop. So the device will reset your monitoring for that month and send you back. They can be locked out. The devices will lock sometimes if you have too many high BACs, or if the detects you tried to bypass it, it can lock where you need to have it towed. Some states also allow remote unlock codes, where you have to call the manufacturer and they will give you a remote lockout code that you punch in, and then you have so many days to then report back to the vendor installation location to have the device verified it's working correctly and the data downloaded again.
Great, thank you. This question is for Maureen. Maureen, you referenced that there's data that compares ignition interlock costs to incarceration costs. And the question is if you know of any report that you could provide that actually has that information.
Yeah, I can provide something to you through going back through my files and provide it for everybody who's been on the webinar at a later date.
Okay, great, thank you. Our last question is, what are some penalties for vendors if they commit violations?
So vendors if they commit violations. So do you mean if a vendor violates the terms of that state's contract with them?
Yes.
Okay. Well, it really depends on the state and how the arrangement is reached. So if they have a vendor agreement through an RFP, then whatever the normal process would be for that state to take action against a contractor would probably be the one that you follow. If it's a state that just has a contractual agreement with a interlock manufacturer, then usually the penalty is explained somewhere in the contract. For us here in Maryland, if a vendor violates one of the conditions of the agreement, there is a specific clause that dictates how we have to inform them, their response time, and what the potential actions are. You know, it really varies from jurisdiction to jurisdiction depending upon how their selection process is identified.
Thank you, Tom. I want to remind all attendees that this is recorded and the slides will be available on NCSL's website, the same site that you registered on, within 24 hours. So